Go on the record in People versus Richard Trepanier. This is file number 255091. The record should reflect that Mr. Trepanier is present here in the courtroom today. If I could have counsel put your appearances on.
Ryan Ziegler on behalf of People.
Thomas Seeger with on behalf of Mr. Trepanier.
This is the date and time set for a sentencing hearing in this case. Sir, have you had an opportunity to go through the pre-sentence report and talk to Mr. Seeger about that?
Mr. Seeger,
Okay. Mr. Seeger, are there any additions, deletions, or corrections to that report?
No, Your
Are there any challenges to the scoring of the guidelines?
They're not, Your
Anything, I'm sorry, Mr. Ziegler, do the people have any additions, deletions, or corrections?
No, Your Honor.
Any challenges to the scoring?
No, Your Honor.
Anything on behalf of the people for allocation today?
Your Honor, I would support the recommendations contained in the PSI. It's very concerning to me, just the facts of this case, that the defendant was in possession of methamphetamine and was operating a vehicle under the influence of methamphetamines. So the facts are very concerning to me. I think they might warrant more than what the recommendation is. However, he is 10-year gapped. The guidelines are 0 to 6. I think the recommendation of probation under those circumstances is probably appropriate. And hopefully Mr. Trepanier will be able to demonstrate to the court that his criminal history is truly in the past.
Thank you, Mr. Seeger.
And I would likewise generally agree with the recommendation, in as much as I don't think the jail time is appropriate. And primarily, Your Honor, I'm reminded of, this came to me this morning when I was driving to work this morning, that there was a case that was in Crawford County that was in front of you. I'm forgetting the client's name, and it doesn't really particularly matter, but the court keyed in on that that particular person who was on bond for approximately 1 year didn't have any positives, didn't have any highs, and the court was generally impressed that that person had generally stayed out of trouble, followed the conditions of the bond, and therefore didn't really do anything with this particular case. And I'm not necessarily comparing one case to another, but I'm just merely saying that this case occurred in around 2022. He's not had any other cases that have been picked up during that time period. He has generally stayed out of trouble. He was going through some difficult points in his life. He was making bad decisions, and I don't have any excuse for it or reasoning as to why that occurred, other than he was going through some hard times in his life. But I think he has changed his life significantly. He's expressed to me that, you know, I don't want any problems with the court, I don't want any problems with law enforcement, I don't want to have anything to do with drugs. And I think for the most part, he's generally stayed out of trouble. He's not created situations where he's been in trouble. He was not aware that there was a warrant out for his arrest. He had indicated that throughout the years, like, law enforcement had stopped by for various reasons unrelated to any conduct of his. But they had never said anything about a warrant or anything. And had he known, he would have immediately done something with it. But because an appreciable period of time has passed and he's not picked up any new files, it's probably a good indication that he's not likely to reoffend in some way. And so the only real question that I had would be whether or not the court requires him to be placed on probation, primarily because I don't want to say he's been on probation since 2022, but he hasn't picked up any new files. So there's probably a pretty decent time period for which the court can rely on that he's not likely to reoffend. Moreover, during the course of his bond, he's not offended his bond either. And so I do recognize, and I'm not saying that probation wouldn't be appropriate. I'm just questioning whether or not it's necessary in this limited circumstance, given that an appreciable period of time has passed. He's not picked up any new files. He generally stays to himself, and he's just trying to make right with this particular case. So he's remorseful for what he's done. He recognizes that he needs to make better decisions. He's expressed about that to me throughout the case. So to that end, I would just ask the court to generally follow the recommendation. Just ask the court to consider whether or not probation is required.
Thank you. Mr. Trepanier, anything you wanted to say today?
There's no excuse for what I did. And shouldn't have happened. It will never ever happen again. Past. Besides that incident, I did pretty good. I'm doing good. I'm doing good now.
I did read through the report. I'm familiar with what happened in this circumstance, as well as your circumstances generally in your history. I tend to agree with Mr. Seeger. I mean, this incident occurred in 2022, so a significant period of time ago. There's no indications that you had any trouble while you've been on bond, which, you know, goes back to, it looks like last June anyway. And no, you know, arrests or charges in between when this happened and now. All of that indicates to me that you seem to be back on the right track. There was a significant gap in your criminal history. And so I do think that some probation is appropriate. I don't think jail time is really going to serve the interests of the community or the court at this point, given the underlying nature of the charges and the amount of time that's passed without you having any issues since this. But I do think a period of probation is appropriate. You know, if you do well on probation, then your agent can recommend you for early discharge and you can be done with that as early as 6 months. So I think ordering the probation is appropriate just to have some monitoring, some testing to make sure that you're on the right track and staying on the right track. And again, if you do well, there's no reason why you can't be released on probation early. So I am going to follow the recommendation. I think it's well crafted and I think it addresses all the factors that the court needs to look at. So the court is going to sentence you to probation for a period of 1 year. The court's going to adopt as the conditions of the probation all the terms and conditions listed in the report, which includes payment of a crime victim's assessment of $130, court costs of $325, attorney fees of $350, a DNA testing fee of $60, $118 state costs, $200 fine, and $30 per month of supervision fee while you're on probation. The court is going to sentence you to 3 days in the Kalkaska County Jail with credit for 3 days served. You do have the ability to seek an appeal of this sentence. Travis, how did you want to
Your Honor, we kind of case just before you kind of points to the issue we have here. Mr. Flowers waived his prelim based on a 7411 offer. There is a old marijuana conviction out of Sheboygan. It shows dismissed. Mr. Ziegler, with his experience with lien, believes it would normally show 7411. I looked it up just a minute ago online, actually talking with Ms. Wagner about the process she would take to, and it doesn't basically shows what Mr. Ziegler sees. We would ask for an adjournment. So maybe so I will call Sheboygan and see what records, if any, they have. It is a misdemeanor. It is rather old. As I told Mr. Flowers, they may tell me what's on the computer is what there is. But to try and look into it a little more, we'd ask for a 30-day.
Mr. Ziegler, is there any objection to that?
No, Your Honor.
Mr. Flowers, have you had a chance to speak with Mr. Travis about this delay?
Yes.
Do you have any objection to that?
No.
All right, then the court will set this for a plea hearing status conference in about 30 days. Mr. Flowers should be notified of the date and time of that hearing by notice, the way you got the notice for the hearing today.
Okay.
Make sure that you stay in touch with Mr. Travis so that you're prepared to go forward on that day, okay?
Okay.
Thank you.
Thank you, Your Honor.